Good morning. 498A, then Dowry Prohibition Act case was pending between the husband and wife. That was quashed by the Supreme Court on simple ground that since the dissolution of marriage was granted and subsequently both married separately, therefore, on condition that 7 lakhs agreed to pay to satisfy all dues of Sridhana and belongings, charge sheet was quashed. Dowry provision number 3 and 4, 498A, 323 and 406. AR 2021, Supreme Court 3087, Lieutenant Colonel S.K. Hari versus State of Uttar Pradesh. So, hereafter on every deliberation, I will give citations title and also give you the lecture pertaining to the APP exam for some reasons. Now I would like to take you to section 84. 84 deals with insanity, general exception insanity. For insanity, first Magnoton rules. The Magnoton judgment has given some guidelines when insanity can be claimed. Second thing was that lucid interval. Some persons may be insane for a certain period, may not be insane for the whole day. So I will onus is on the part of accused who pleads insanity. But here the Supreme Court has given a different verdict, waiving that onus of proof, shifting the onus proof on the prosecution. So this judgment may be most helpful to understand section 84 of IPC. Injured witness stating appellant to be not of unsound mind cannot absolve prosecution of its primary to explain why the plea of unsoundness of mind taken by the accused was untenable. They say, we shall now consider the efficiency of other medical evidence and the defense evidence to examine if a reasonable doubt is created with regard to mental state of the appellant at the time of commission of the assault and a preponderance of probability, coupled with a complete lack of consideration of the evidence. PW 14, merely because an injured witness, who may legitimately be classified as an interested witness for obvious reasons, may have stated that the appellant was not of unsound mind, cannot absolve the primary duty of the prosecution to establish its case beyond all reasonable. Explain why the plea of unsoundness of mind taken by accused was untenable. This is Devidas Loka Rathod versus State of Maharashtra. Then another judgment was trial court not considering and appreciating previous history of insanity, swayed by medical report after 5 years in custody, during which period appellant condition might have improved with better and continued medication. Appellant court also not analyzing material on record properly, conviction not sustainable. It's also most important to answer section 84. The trials erred in proper consideration and appreciation of evidence, virtually abjuring all such evidence available, raising doubt about mental status of the appellant at the time of commission of the offence, so as to leave his conviction as foregone conclusion. The trial judge unfortunately did not consider it necessary to put further question to PW 14 with regard to the hospitalization of the appellant immediately after occurrence and why the prosecution not placed the necessary evidence in this regard before the court. Truth therefore remained elusive and justice thus became casualty. The trial judge therefore erred in his duty as observed in State of Rajasthan versus Aniales Anif, AR 1997 6 Supreme Court 162. This is what the similar judgment of that. Then one another judgment which is against defense side. Section 84 read with Section 105 Evidence Act. Unsoundness of mind, legal and medical insanity at the time of commission of offence as collated from the evidence of conduct of which preceded, attended and followed the crime. Burden of proof depends on preponderance of probability enough. Then burden shifts on prosecution. This is also same judgment. So all these judgments should be strictly followed. So this Devidas Lokdas Rathod case has been Devidas Loka Rathod versus State of Maharashtra. His most important judgment, you can go with all these important aspects. Then I would like to give some hints how to prepare for reading for understanding the IPC. As I already told that reading of sections are most important. That is what they say, reading out principles. The question of punishment, the most important chapter 3, is controversial sections are there. Punishment to which offenders are liable under provision of this code are death, imprisonment for life, imprisonment which is of two descriptions, namely rigorous, that is with hard labor, simple, forfeiture of property, fine. Then 53A, construction of reference to transportation. Transportation of life means exiling the accused from society and confine him at particular place where he could live on observation. Subject to provision of section 2 and subsection 3, any reference to transportation or any other law for time being posed or any instrument or order having effect of any such law or any enactment repealed shall be considered as a reference to imprisonment for life. Therefore, the transportation punishment since has been removed. They say that transportation for life means imprisonment for life should be constituted. Then commutation of sentence of death. In every case in which sentence of death shall have been passed, the appropriate government may, without consent of the offender, commute the punishment for any other punishment provided by this code. So, if commutation of sentence of death may be modified to any other sentence. Every case in which sentence of imprisonment life shall have been passed, the appropriate may, without consent of offender, commute the punishment for imprisonment for commute the punishment for imprisonment of either description for a term not exceeding 14 years. This is also the government, it is power under the government. 54 and 55 are power of the government. That means that is correlated to CRPC. I think 432. 55A, definition of appropriate government. That is, they say when union, if it is union, executive power of the union, the central government will be appropriate government. State will be executive power of the state, the government of state which in the offender is sentenced. These all are simple to understand. Section 56 was deleted. Then section I will stop here because section from 57 to 75 most important provisions. I have to discuss it independently. So I will leave here because that relates to what will be the fraction of judgment, why that provisions are there. That I will discuss tomorrow. Best wishes.